and sent to the governor. Senate Bill 207, the clerk will read.
Senators Brett, Daniels, and Muhammad. Senate Bill 207, a bill to be entitled Various Raise Age Changes. General Assembly of North Carolina enacts.
The gentleman from New Hanover, Representative Davis, is recognized to debate the bill.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, Senate Bill 207, the PCS that was heard earlier in the Rules Committee today, modifies certain provisions of the Juvenile Justice Reinvestment Act as recommended by the Juvenile Justice Advisory Committee. It modifies the minimum age of a delinquent juvenile and an undisciplined juvenile, and it modifies the law dealing with juvenile court mental health assessments. I would say that that portion with the mental health assessments is identical language to a bill I previously introduced that passed the House unanimously, House Bill 615, Juvenile Court Mental Health Assessments. If I could give you a little history, the bill came over from the Senate. It came to be heard in the House Judiciary 1 Committee, and there was a PCS. In preparation of that PCS, I worked with Representative Marcia Moray and a lot of the other stakeholders who had been working on this previously, including members of the Juvenile Justice Reinvestment Advisory Committee. That bill, or PCS, passed out of the House Judiciary 1 unanimously. It then went to the Rules Committee. Today, when it was heard in the Rules Committee, that PCS was not what was presented to the Rules Committee. Rather, a new PCS was introduced, which had everything in it that the original PCS that passed out of the Judiciary 1 Committee unanimously had, with the exception of Part 5, which was recommended by the Association of District Attorneys. That did receive a favorable report from the Rules Committee, and Mr. Speaker, with your permission, I'd ask for Representative Stevens to explain what the changes were in Part 5, which once again were the only changes from what came out of the Judiciary 1 Committee. Thank you, Mr. Speaker.
Yes, sir. The lady from Surrey, Representative Stevens, is recognized to debate the bill.
Thank you, Mr. Speaker. And members of the House, what this bill does is said that 8 and 9-year-olds who commit a certain level of offense need more than 6 to 9 months of counseling. And that's something we've been looking at. There's issues raised about competency for juveniles. And when an adult commits a crime, we don't just forgive it. We don't just say walk away. We don't know what we're going to do with juveniles who supposedly don't have the competency. The offenses that we have for 8 and 9-year-olds are A through F felonies, A through G felonies. Now, you keep thinking, what could a juvenile do that would be that bad? These are juveniles, and I'm reading from some of the statistics of the things that juveniles did. We have the information without having the names of the individual. We have first-degree arson. We have first-degree kidnapping. We have indecent liberties between the children, engaging in sexual acts. We have robbery with a dangerous weapon by an 8 and 9-year-old. We have a second-degree arson. We have a second-degree forcible rape, which is engaging with vaginal intercourse with another person by force and against their will. We had several of those by 9-year-olds. We have at least 9 offenses of second-degree forcible sexual offense, which is engaging with some sex act with another person against their will. We have another sexual offense, which is with a person knowing that that person is mentally incapacitated and unable to engage. These are 8 and 9-year-olds, and we believe 9 months of counseling will fix this problem. We can keep jurisdiction over them longer in juvenile court than this. We also had one, believe it or not, trafficking in opium and heroin. A 9-year-old trafficking in opium and heroin. We need more than 6 to 9 months counseling for these children. We need to get them help. And until we can otherwise change the system, we need to ensure that they're going to stay under our court's jurisdiction.
For what purpose? The lady from Durham, Representative Maury, rise.
To put forth an amendment if this is the proper time.
It is. The ladies recognized, send forth an amendment. The clerk will read.
Representative Moore moves to amend the bill on page 6, lines 27 through 33, by deleting those lines.
The lady has the floor to debate the amendment.
Thank you, Mr. Speaker. I'd really like to thank Representative Davis, who did a yeoman's job in carrying this bill. This has not been easy. And a couple of years ago, we introduced a similar bill and went to a study. Should North Carolina raise the minimum age of jurisdiction from 6? We're the only state in the country, 6-year-olds can be under juvenile delinquency court jurisdiction. So for 2 years, the JJAC, Juvenile Justice Advisory Committee, appointed by members the Speaker has appointed and the Senate Pro Tem, consisting of law enforcement, juvenile advocates, court counselors, district attorneys, defense attorneys, have met and discussed this. Hours. I've been on some of their calls, hours of talking about this. Their recommendation is not what we have in this bill right here today that was amended last night at 6:30. Their recommendation is a clean statement. Juvenile jurisdiction should start at the age of 10 in North Carolina. There are no exclusions. And I know Representative Stevens just went through a plethora of horribles, of bills, of kidnapping, of trafficking in opium committed by 8 or 9-year-olds. Well, guess what? Probably most of those cases had an adult or an older juvenile co-defendant. What we are saying that is endorsed by ALEC, is endorsed by the ACLU, Children with Disability Rights, NC Child, 17 organizations endorse this. Raise the age, do not exclude based on offense. Because what we are saying, and what even our North Carolina law says about capacity, our statutes say no person may be tried, convicted, sentenced, punished for a crime when by reason of mental illness or defect that he is unable to understand the nature and object of the proceedings against him, to comprehend his own situation in reference to the proceedings, or to assist in his defense in a rational, reasonable manner. 8 and 9-year-olds, 3rd graders, 4th graders, cannot assist in their defense with an attorney. They are impulsive. Their intellect is not fully informed. As a judge sitting in juvenile court watching 8 and 9-year-olds look around the room, have no idea the role of a defense attorney, prosecutor, or judge. And to watch them on occasion go through a plea transcript of 2 pages, having to say yes or no, they have no idea what these words mean. Adjudication, plea negotiation, disposition, adjudication. Most states that have a statutory minimum age in the United States, it is age 10. 3 of our states, it is age 12. We are doing the right thing by taking 6 and 7-year-olds out. I am asking in this amendment, make it 8 and 9 as well. And I will also say, if you think an 8 or a 9-year-old who is charged or may commit second-degree murder or a kidnapping, that we can really do a lot with that child under our current law, you can't even send them to a youth development center until they're age 10. You put them on probation. So I ask you to support this amendment. Let's have North Carolina in the mainstream of the country, recognizing what child psychiatrists say, what mental health experts say. Do the right thing. We will get these kids consultations. We will get them to mental health. We will get them to social services. We will support them and their families. But do not start them off with a delinquency history at the age 8 and 9 because of an A through G felony. Thank you.
For what purpose does the gentleman from New Hanover, Representative Davis, rise?
Speak on the amendment.
The gentleman has the floor to debate the amendment.
Ladies and gentlemen of the House, I'm really between a rock and a hard place on this. As was stated earlier, I worked really hard on the PCS that was heard in the Judiciary 1, and it was based upon what the Juvenile Justice Advisory Committee recommended. When it came to the Rules Committee today and the changes were made that Representative Stevens has talked about, I was informed that this was something that had been agreed upon between the Association of District Attorneys and some of the stakeholders from the Juvenile Justice Advisory Committee in order to get the district attorneys on board with the bill and move it forward. I wish this had all had been handled when it was before the Judiciary 1 Committee so we could have gotten it all straightened out then, but unfortunately it wasn't. So I'm in a position of kind of like when 50% of my friends for it, 50% of friends against it, and I always agree with my friends. So I think what you just need to do is listen to the arguments that have been made and vote your conscience. Thank you.
For what purpose does the gentleman from Randolph, Representative McNeil, rise?
To debate the Maury Amendment.
The gentleman has the floor.
Thank you, ladies and gentlemen of the House. You've heard a good emotional plea today about 6, 7, 8, and 9-year-olds, and we've all got them, you know, children, cousins, nephews, whatever. But don't let that tug at your heartstrings. And if you want your heartstrings tugged, think about the victims of these crimes also and how their lives are affected by this. Representative Stevens did a great job, and I won't, you know, belabor that a lot, but a lot of serious crimes. Now, as far as the Juvenile Justice Advisory Commission, yes, they make proposals, but it is our duty to make policy, not theirs. Now, I'm not against the Juvenile Justice Advisory Committee. As a matter of fact, the first 4 parts of this bill, if you look at House Bill 252 that I sponsored and several other people in this sponsored, that is exactly the same bill as the first 4 parts of this bill that I sponsored and ran for the Juvenile Justice Advisory Committee and Billy Laster, the Director of Juvenile Justice. So I'm not against the Juvenile Justice Advisory Committee. They got 100%. If you go through the first 4 parts, they get 100% of what they asked for. And if you go through Part 5, they got about 95% of what they asked for. So the changes were very, very minimal. It was said in the Rules Committee that over a 3-year period, there were around 1,100 6 through 9-year-olds that engaged in criminal activity. Now, not all of that criminal activity was of the felony level that Representative Stevens talked about. And I could go on, and I went down and break it down. There was about 150 of those that were the level of what we're talking about. The bill as written, without the Maury Amendment, would remove all of those 1,100 from the court system with the exception of 5 juveniles. And that would be for the most serious of crimes. Representative Maury said that North Carolina is one of the states where 6-year-olds, one of the few states where 6-year-olds start still charged with a crime. Well, even without her amendment, if you leave the bill as it is right now and you vote for it, 6-year-olds would not be charged with a crime, any crime in the future. Neither would 7-year-olds if you don't vote for the Maury Amendment. All H felonies, all I felonies, all misdemeanors for 8 and 9-year-olds, off the table. Can't charge an 8 and 9-year-old with them. Only the most serious A through G felonies, your sexual assaults, your rapes, your armed robberies, your arsons, that's the only thing that's left on the table. And you know what? The juvenile justice people are still left with the ability to divert those cases, and the judges in those cases still have the ability to find the child incompetent to stand trial. So what you're looking at is a firewall. You know, if you pass the Moria Amendment, then no 6, 7, 8, or 9-year-old will be able to be charged with any crime in the state of North Carolina ever again. Period. No crime. 9-year-old murders his parents. He gets 6 months of counseling. And if that don't work, he gets an additional 3 months. So I think what the JJAC committee and others want to do is a bridge way too far. You're eliminating 6, 7, 8-year-olds. You're eliminating 95% of the crimes that they commit from adjudication, and only leaving the most serious ones. So I beg you, don't do this. Vote against the Moria Amendment. It is a bridge too far. Thank you.
For what purpose does the gentleman from Guilford, Representative Quick, rise?
To debate the amendment.
Gentleman has the floor.
Thank you, Mr. Speaker. Allow me to recast the image of 9-year-olds as we're here debating. They are kicking, they are running, they are throwing, they are playing ball. It is easy to, as previous representative said, to become emotional about that, but that emotion runs both ways. We do make policy. It is our responsibility to make policy, but we don't make policy in a vacuum. In fact, it was the legislative body that put together the JJAC committee, and the JJAC committee came back with this recommendation that was previously approved unanimously, that we did not include 8 and 9-year-olds in this legislation. It's a good bill. 6 and 7-year-olds are taken out. It's good. There are parts of it that are good regardless of the outcome of our vote. But I want us to really consider approving this amendment, which is what the JJAC committee recommended to us, a committee that we put together, not a committee that just came out of the blue. We put this committee together. They studied it. They came up with the recommendation, and the bill that included 8 and 9-year-olds in the exemption was one that was previously approved by this body. These 9-year-old boogeymen that we're talking about, nobody wants any of our children, and certainly the victims of these crimes. Nobody's saying children should be allowed to get away with crime, but recast the image of the 8 and 9-year-olds that we're talking about. They are running, they are kicking, they are throwing. And if we're saying, I heard one of the previous representatives say that we don't let adults get away with these things. If we don't think there's a difference between an adult and a child, God help us all.
For what purpose does the lady from Surrey, Representative Stevens, rise?
To speak a second time.
Lady has the floor.
Thank you, Mr. Speaker. And I just wanted to point out a few things. I really appreciate Representative McNeil's comments, but I wanted to clarify a couple of things. We did not spring this out last night. We've been talking about this for weeks. For weeks. We've been working with a conference of DAs. We've been working with the juvenile justice group, and we had a partial agreement in the last couple of weeks. There were a couple of things we wanted that were even further than this. But we went to the part that we all agreed upon, which was to keep 8 and 9-year-olds in this situation for A through D felonies. This week is when we reached that final agreement. I happened to be in that Judiciary Committee meeting, and I didn't vote, but I don't think there were any Republicans in there but the chair and the co-chair. 8 and 9-year-olds out playing, kicking a ball, having a normal, good childhood are not committing sexual offenses, rapes, selling drugs, those kinds of things. And if there's an adult that's engaging in that activity with them, we need longer than 6 to 9 months to work with those children. Children this age will not wind up in jail. They will not wind up in adult court. They will not wind up in a youth detention center because they're too young. What it does is give the court longer to monitor the situation, longer to follow these few children. And as Alan McNeil told you, Representative McNeil told you, 1,200 of those kids are out of the juvenile system by this and into that counseling situation. It's those 50 or 60 cases that have happened with just a few juvenile defendants, juvenile delinquents that we are tackling with this problem. Those who have this kind of background or emotional trauma or something that's caused them to act out in this way need more care than they're going to get in 6 to 9 months. We are equating the behavior they did with the kid who just acted up in school, the kid who was truant, the kid who stole candy because it looked good at the store. Those kids are out of this altogether. This is only those most serious of offenses. We had this agreement with Juvenile Justice and the Conference of District Attorneys. They are all in support of this, and we ask that you continue to support this.
For what purpose, the gentleman from Wake, Representative John Rice.
I'll debate the bill.
Gentleman has floor to debate the amendment.
Thank you, Mr. Speaker. Members, I'm not going to speak long. I just want you all to have an idea of the 21 folks who are on this Juvenile Justice Advocacy Juvenile JJAC Committee. I'm not going to give their names, but I'm going to give the designation from which they came. Representative from the Victim Advocacy Community. Representative from the Juvenile Advocacy Committee. Sheriff. Representative from the Victim Advocacy Committee, that happens to be a judge. Representative from the Juvenile Advocacy Committee. District Attorney. Representative from the Juvenile Justice Planning Committee of the Governor's Crime Commission. Executive Director of the North Carolina Sentencing and Policy Advisory Commission. Chief Court Counselor, Rural County. Director of the Division of Mental Health, Developmental Disabilities, and Substance Abuse Services of the Department of Health and Human Services. A Clerk of Superior Court. Deputy Commissioner for the Juvenile Justice of the Division of Adult Correction and Juvenile Justice of the Department of Public Safety. Police Chief. Superintendent of Public Instruction, Superior Court Judge, Chief Court Counselor, Urban County, Chief District Court Judge, Assistant Public Defender who handles juvenile matters, Assistant District Attorney who handles juvenile matters, Director of the Administrative Office of the Courts, and Juvenile Defender in the Office of Indigent Defense. I read all those so you understand. This is not some group of individuals who selected willy-nilly. These are all responsible individuals selected to participate in a committee established by this body, this legislative body, the House and Senate of the North Carolina General Assembly. We set them at a task to look at these issues. They looked at them and came back with a recommendation that passed muster several times until very recently. I recommend that we support the Morey Amendment. Thank you, Mr. Speaker.
For what purpose does the lady from Durham, Representative Morey Rice?
Speak on the amendment a second time.
Lady has floor to debate the amendment a second time.
Thank you, and I appreciate the time we're taking on this amendment. What I have just heard, that we have worked on this, we have agreed with the DA's conference, we have agreed with the Sheriff's Association. Well, that we did not include this side of the aisle. And we talked about the budget, and we talked about our doors are open, and let's talk, and let's share ideas. Well, it sure didn't happen in this. I've worked on this for years. Have I been a part of any of the conversations? No, iced out. I've spent my life working with kids and in these juvenile courts. And what I quoted you about capacity is in our statutes, and we're ignoring that if we do this carve-out. And because we've heard some heinous crime examples, kids, 9-year-olds killing their parents, that doesn't change the definition of capacity. I urge you to support this amendment. Let's do it clean. Let's follow the majority of states. We will get these children help. It doesn't end at a magic 6 to 9 months. Mental health services are available throughout our state, social services, but not punitive. for these young children who do not yet have the capacity in a courtroom or to create criminal intent. Thank you.
For what purpose does the gentleman from Wake, Representative Jones, rise?
Speak to the amendment.
Gentleman has the floor.
I guess I'll add my voice to the other two former judges in this chamber and say that we don't need to do this on the 9-year-olds. I'm going to cite something. I'm sure all of you remember this happening. Back a ways, two guys grabbed the president of the student body at UNC and took her around the bank, made her take money out, and then they killed her. I was on the bench then. And one of those guys was on probation. And after that happened, and we all know that's a horrible, ugly, vicious, sinful piece of work. Awful. But after that happened, I, as a judge, for a couple, 3 years, watched probationers who had been doing excellently get recommendations of revocation, 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 because the officers became scared that they would let that one guy through who would do the ugly thing those guys did to that young lady. What I'm saying is we shouldn't let a couple, 3 instances of some bad 9-year-olds that would do horrid things control the policy for thousands and thousands of the 9-year-olds who would never do that, ever. I just think it's bad policy to let the ugly case drive the policy. And that's what happened in that case, and I remember witnessing it as a judge, and the recommendations just totally flipped. Good probation officer, suddenly their judgment got blinded. I don't want to make that one mistake. So I'm not going to give this good guy a good recommendation because he might be the one that slips through. And that's not the way we should make policy. So I endorse the amendment and the remarks of Representative John, Representative Maury.
9-year-olds.
Thank you for the question. One is you're stigmatizing them. You're calling them, labeling them delinquents in a legal matter, in a legal term that can follow them. There are punitive matters because they can go to detention. A judge can lock them up in detention pending the next court hearing, pending whatever reason that judge wants to do. They can be locked, strip searched, go into detention. They're not eligible to go to Youth Development Center, but I would say that's pretty punitive. Their families, they would have to be required to report to probation. They would have to be required to do any number of things a judge would require. That may not be punitive, it may be helpful. But usually dispositions, and as we talk about the more serious offenders, and I think that was referenced, they need sanctions, they need punitive measures. And on these children that young, many of whom are victims themselves of poverty, of crime, of abuse in their family, is this the way we want to respond to them?
And, Mr. Speaker, if I might also ask, maybe Representative John, but Representative Maury or Stevens may know the answer to this question. There have been a number of references to the recommendation of the commission or committee that was set up, and Representative John enumerated the membership. Was that a unanimous recommendation from that group, or do we know?
Is there a member that has knowledge of that? Representative Moore?
They issued a report, and the report was unequivocal that they wanted to see the minimum age raised to the age of 10 with no exclusions, and they wanted any 11 and 12-year-old who would be charged to have a capacity hearing before a judge before they could have any adjudication.
Representative Stevens, did the lady also wish to respond to that question?
Thank you. I will tell you that capacity is still very much at issue. She indicated they issued the report, but I do understand that it was not unanimous. I've talked to a couple of members on there who either weren't present or would have voted against it or did vote against it. So I don't think it was a unanimous report.
For what purpose, the gentleman from Randolph, Representative McNeil, rise?
To debate the amendment a second time.
The gentleman has the floor.
Thank you, and it's good points. Representative Blackwell, that's exactly one of the questions I was going to ask, of if it was a unanimous support from the 21 members, and I gather that it wasn't. But anyway, I think we're forgetting, as we've gotten emotional again, and we've talked about these kids that are running and kicking ball and all that stuff. But one thing that nobody keeps, I think I'm the only one that has mentioned the victims in this. Heaven help that we should stigmatize a 9-year-old that has raped someone. What about the person they raped? Has that stigmatized them? Without the Maury Amendment, this takes all the 6 and the 7-year-olds completely out. It doesn't make a difference what crime they commit. You can't charge them with it. It takes 95% of the crimes that a 8 and 9-year-old could commit totally out of the system. Can't charge them with a crime. It just leaves the A through G felonies, which is the most serious and heinous of the crimes. Don't forget the victims. You can talk about the perpetrators, you can talk about the juveniles, you can talk about their mental capacity all you want. But if they've got the mental capacity to rape someone or point a gun at someone or commit an armed robbery, whether there's an adult involved or not, it doesn't make a difference. There's still a victim on the other side of that, and that's what everybody seems to be forgetting in this. So once you vote for this, if you vote for the Maury Amendment, you take 6, 7, 8, 9-year-olds completely out of the system. Never again in this state will you ever be able to charge them with any crime, no matter what it is. I think that's, like I said before, that is a bridge too far. Once you ring that bell today, if you vote for the Maury Amendment, you can't unring it. You can't go back. Please vote this amendment down.
For what purpose, the gentleman from Durham, Representative Hawkins, rise?
To ask a question of Representative McNeil.
Which member?
Representative McNeil.
Representative McNeil's gentleman yield?
I do.
He yields.
Would you mind laying out statistics of the crimes, the number of crimes, the prevalence of 8 and 9-year-olds doing some of the heinous crimes that you outlined? Because I'd love to hear, and seriously for educational purposes for the body, I think that would be enlightening, because I think we are maybe not talking about this as completely as we could without the detail and those types of statistics to give us some clarity, because not all of us are law enforcement or an attorney.
Yes, sir. I'd be glad to, Mr. Speaker, if I'm allowed to reference this sheet
Gentleman
of
is
paper I
allowed
have
to
here.
respond.
Okay. Assault by pointing a gun, 1 9-year-old. Assault on a government official, 1 6-year-old, 11 8-year-olds, and 10 9-year-olds. Assault inflicting injury by strangulation, 1 9-year-old. Assault inflicted serious injury, 1 6-year-old, 1 7-year-old, and 1 9-year-old. Assault on a school employee, 1 6-year-old, 2 7-year-olds, 3 8-year-olds, and 12 9-year-olds. Assault with a deadly weapon, 1 6-year-old, assault with a deadly weapon, 2 8-year-olds, 2 9-year-olds. Breaking or entering, a 7-year-old, 2 9-year-olds. Burning an occupied dwelling, 1 8-year-old, an unoccupied building. Burning personal property, a 7-year-old and a 9-year-old. Crime against nature, 5 8-year-olds, 6 9-year-olds. First degree arson, 1 7-year-old, 1 9-year-old. First degree kidnapping, 1 7-year-old and 1 9-year-old. First degree sexual exploitation of a minor, 2 9-year-olds. Do you want me to go on? Because I've got several more. I just don't want to waste anybody's time.
Follow, Mr. Speaker. Do we know how that also equates to the number of students that are involved in the criminal justice system? And then, there are 1.2 million kids who are in at least the public school system. So we're talking about a really minuscule number that you're trying to ask us not to address by voting against the amendment. Is that correct?
Over the period of this study, there were a little over 1,100 juveniles, 6 to 9-year-old, that committed a little over 2,000 crimes. So quite often when a juvenile is charged with committing a crime, they're charged with committing more than one crime. So you've got 1,100 juveniles, but a little over 2,000 crimes. Some of them may have committed just one crime, some may have committed 3 or 4. Of those 1,100, 142 by my count were the most serious crimes, some of which I mentioned. There were several I didn't mention, such as second-degree forcible rape, 1 8-year-old and 13 9-year-olds. So I didn't read everything on the report, but of the 1,100 juveniles that were encompassed this study, without the Morey Amendment, the way the bill stands right now, you're going to take all 1,100 of those out of the system except 5. And that's the 5 that have committed the worst crimes. So you're getting 95% of these 6, 7, 8, 9-year-olds out of the system. And I think that is as far as we need to go. But if you need any more statistics, I've got several more I can read. But that is information that was provided to me by the Department of Public Safety.
Speak to the bill. To the
Chairman
amendment.
has the floor.
Thank you for that information. And as you've heard from many, we're still talking about 6 to 9-year-olds, and we're talking about a very small number. And I hope that you'll join Representative Morey and vote for this amendment. Thank you.
For what purpose the lady from Durham, resident of Austin, rise?
I was going to ask, thank you, Mr. Speaker. I was going to ask Representative Morey a question, if she'll yield.
Representative Morey, ready to yield?
I do.
Yield.
Thank you, Mr. Speaker. Just briefly, much has been made of the fact that this PCS only applies, or the modification for 8 and 9-year-olds applies to the most serious felonies. And so I just wanted to clarify for everyone's benefit that our felony code is arranged alphabetically A through I, and this PCS applies to felonies A through G, only excluding 2 felony classes. Am I correct?
May I respond? Sure. Okay, thank you. Yes, it does not include H and I's. H's are like breaking and enterings, larceny under $1,000.
Thank you.
Thank you.
Members, we have one more light. Are there any other members who wish to debate this amendment? All right. Would ask the members to perhaps keep their remarks short. We've not called the question, but just sensing the room, I think most members are probably ready to vote. For what purpose of the gentleman from Wake, Representative John Ross?
Very briefly, Mr. Speaker, to debate the bill.
Gentleman has the floor.
The second time, thank you. Members, in the letter of transmission of its recommendations dated May 6, 2021 from the commission, the committee, the JJAC committee, to the General Assembly, it states its recommendation that it supports raising the minimum age of juvenile jurisdiction for all offenses from 6 to 10. That doesn't resolve the issue of whether it was unanimous or not. However, later in that same transmission, there is a third recommendation, and they note specifically one dissent was entered from this specific recommendation. So I infer from that, and I suggest to you that the recommendation of the JJAC committee was indeed unanimous in this regard. Thank you, Mr. Speaker.
Further discussion, further debate on the amendment? If not, the question for the House is the adoption of Amendment A1 sent forward by Representative Morey. Those in favor will vote aye. Those opposed will vote no. The clerk will open the vote. Representative Zinger wished to vote. Representative Davis wished to vote. Clerk will lock the machine, record the vote. 41 having voted in the affirmative, 58 in the negative. The amendment fails. We're now back on the bill. Further discussion or debate on the bill. For what purpose, the gentleman from Guilford, Representative Quick rise.
Speak to the bill.
The gentleman has the floor.
Previous argument notwithstanding, this is a good bill. It does do a good thing for North Carolina. It brings us in line with other states. It helps us in our criminal justice system, particularly as it deals with juveniles. And I also want to say I make no apologies for being emotional about the children of North Carolina. It's an emotional situation, and we all want the best thing for our children. We disagree sometimes on the way to get there, but I want to commend the bill sponsors for this bill. I want to commend our state if this vote is favorable, that we've made a move in the right direction. Thank you, Mr. Speaker.
For what purpose, the gentleman from Wake, Representative John rise.
Debate the bill briefly.
The gentleman has the floor.
Thank you. And notwithstanding, similar to Representative Quick, my previous concern about the shortcomings of this bill, I think otherwise it is a very, very adequate and responsible bill. I'll be voting yes and ask respectfully that you join me in doing so. Thank you, Mr. Speaker.
For what purpose, the lady from Durham, Representative Morey rise.
It will not be to send up a Second Amendment.
He's recognized to debate the bill.
Just to briefly say thank you very much for a good debate. I honor everyone and your comments and your thoughts and your opinions. This is a good bill. It will help a lot of kids. We'll be back sometime, but I do encourage you to vote for the bill.
Further discussion, further debate? If not, the question for the House, passage of Senate Bill 207 on second reading. Those in favor will vote aye. Those opposed will vote no. The clerk will open the vote. Clerk lock machine record the vote. 101 having voted in the affirmative, 1 in the negative. Senate Bill 207 passed the second reading without objection. Be read third time.
General Assembly Bill Klein acts.
Question for the House, passage of Senate Bill 207 on third reading. Those in favor will say aye. Those opposed, no. The ayes have it. Senate Bill 207 having passed third reading will be sent to